Hello, my name is Robert Sterne, and I am a founding director of the intellectual property specialty firm of Sterne, Kessler, Goldstein Fox in Washington, D.C. I am also editor of Patent Office Litigation, the first and most definitive book published on the new contested proceedings at the United States Patent and Trademark Office. These new contested proceedings became operational in September of 2012. It is June of 2013, and I want to talk to you about an important issue of litigation stays relative to these new contested proceedings. By this I mean stays in either the district court or the International Trade Commission of their proceedings pending completion of the contested proceeding at the USPTO involving the same patent. Now, based on a dozen or more stay decisions by various district courts involving patents in the new contested proceedings, and the discussions on the subject at 19 national level presentations since September of 2012 that I have made, there is no indication that all courts are going to stay. For many district court judges, it is going to be a very nuanced decision based on many factors. So let's talk about these factors. Now, one factor will be when the contested proceeding is filed relative to the filing of the suit. This relative timing between the two proceedings is extremely important to bring to the attention of the court, because it is the relative timelines between these two proceedings that the court will be considering. Now, another factor is whether the board trial has been instituted, because not all trials are being instituted at the board. Another important factor to address is whether all of the claims in the district court suit have been made part of the board trial. There are many important decisions that have been made so far by the board where they have not instituted trial against all of the claims that are in suit. An additional factor are the grounds of unpatentability that are ordered for trial at the board against the claims relative to what is being raised in the district court. And the type of proceeding that is existing for the patent at the board is very important, whether it's an inter-party review, a contested business method proceeding, an inter-party reexamination, or an ex-party reexamination, or frankly, a combination of those that are involved with the same patent that's in suit is something the court is going to want to know. Now, many judges are troubled about the concept of parallel proceedings involving the same issues and the same patents between their court and the USPTO. But, on the other hand, they are also concerned about the pendency of their dockets, because they're measured on how long their trials take, and the fact that the delay in their trial could easily constitute what is often construed as justice delayed is justice denied. Clearly, both sides in a stay request are going to have to sell their proposed decision to the court. So remember this when you go in and make your arguments and you file your briefs. But it is not a foregone conclusion, I submit, that courts are going to stay, particularly those in the patent pilot program. Now, more than 300 contested proceedings have been filed since September 16, 2012. Now, this is more than one every single calendar day. If the new enforcement paradigm in the U.S. is that a contested proceeding will be filed against every patent in every patent suit, the office will receive thousands of contested proceedings a year. And even with the 200 new judges that are on the board, the new administrative patent judges, such a workload is enormous for each judge. Moreover, many of the contested proceedings will be appealed to the Federal Circuit. The enormity of such a paradigm is starting to register in the patent community. Frankly, at each of the 19 conferences I've spoken at, I could clearly see that most people have not fully comprehended what has happened and what could happen in the future. So now let's address the International Trade Commission. Historically, the International Trade Commission does not stay its proceeding under Section 337 because of a parallel inter-party reexamination. And the reason for this was that the inter-party reexamination took 5 to 8 years to complete, whereas the Section 337 proceeding was much more speedy, frankly, 18 months. So the thinking at the commission was, why stay their proceeding when the Patent Office proceeding takes much longer? But under the new contested proceedings, there is a statutory requirement that the trial be completed within 12 months of being instituted and 18 months in extraordinary circumstances. So obviously the judges in the ITC, the administrative patent judges, are addressing whether the new proceedings will be speedy enough in order for them to stay their proceeding. But in light of the very speedy justice requirements and timelines of Section 337 proceedings at the Commission, I predict, and others, that the Commission will not stay their proceedings even if a contested proceeding is ongoing. There could be one possible exception where the contested proceeding is filed before the 337 action is instituted. That may be the one exception. But I think overall, unless there is a huge time disparity between the contested proceeding being filed much earlier than the Section 337 proceeding, I think that the Commission will not stay. Now, we're going to continue to keep you posted over the next several months on this very important issue of stays, of district court and ITC cases relative to contested proceedings at the Patent Trial and Appeal Board. So stay tuned. Thank you very much.